With my Lord permission, may I mention a case from daily list, serial 9, my Lord. I pray for 2 weeks time. मुझे instruction लेना है विद
Prayer rejected, case fall out होगा तभी
अब
order.
लगा।
यहाँ adjournment पे ऐसे mention करके नहीं है. आपको भी adjournment चाहिए?
Minutes, may I take leave to mention from tomorrow's list minutes, CL number 2, WPL 7287 procedural. I am appearing for the respondent. I have taken minutes consent from Mr. Amit Sinha, Associate Counsel to Mr. Mehta minutes. I am unable to argue the case whether last week I have undergone surgery of mastectomy minutes. So
I will not read the brief for tomorrow.
Yes,
right?
that is my
वो
intention.
mark कर लीजिए. But the case will be adjourned when the case is taken.
Yes,
Are you otherwise okay?
I am otherwise okay, I am having weakness, therefore
No problem. You just even if you are not there tomorrow, the case, Mr. Amit, you inform this court, right? You need not come for the adjournment. You can join online also, if you want.
From daily list under heading for final disposal item 1 WPL 1790 of 2018.
In my last order, I was directed to file supplementary affidavit to bring on record that the order 17/10/2022. Whereby we have been directed to bring on record the FIR, whether lodged or not. That we have filed. The FIR we have.
Where is the number? Yes, take. Give the number of the FIR.
It was registered in 2024.
They will get that. We will ask them to give the number. Registered?
After 2 years.
So what? We do not know what is going to happen. We do not know what is going to happen. One, you sent for FIR, it has now
It
been
was sent
registered.
in 2022.
You see, we are not on the quashing of the FIR. Isn't it?
The affairs of
Pursuant to the order passed by this court,
Right.
and FIR has been instituted. Right?
I am indicating the affairs of the state.
That's कितना ही ऐसा एप्लीकेशन ये लोग उठा कर फेंक देते हैं. It is not something which is unknown to us, isn't it? Now you have registered. The investigation is in progress. Now you tell us what is the case. Why was this FIR to be instituted?
It is for giving overtime beyond the
Yes. You are engaging those persons who are not on your role.
We admit it has come in the inquiry report that they have done the job.
So,
But the limit which we have, can sanction is that we have given 57,000 rupees we have already given for overtime. Beyond that we cannot give.
In fact, they have taken excess work from the employer, excess overtime than as per the permitted limit of the factory acts. And now when they have to make the payment, they are saying that as per
you are not regular employee.
No, I am regular employee. I am regular employee.
So why this FIR was instituted?
The FIR, the court will not have directed.
Please give us the back. You argue your case, we will dispose it off. No, now the FIR has been instituted. You argue your case on that.
I will not be benefited by the FIR. I will be benefited by payment.
That is why. Impugned order is to be seen. The concerned person will be booked, that they will be taken care of. But let us see the impugned orders. Give us the background of the case.
He was the regular employee. He was taken job beyond the.
One person? How many persons?
One person. But in the inquiry, it was found that he has done the work beyond the.
Where is the inquiry report? You see, don't just argue. Show it from the inquiry report or show it from the impugned order.
It's my supplementary.
Supplementary affidavit. Dated 18/9.
Page 7 of the supplementary affidavit. It is 12/12/2020.
Dated 12/12/22.
2020.
There is an inquiry report of 24.
24.
ये है ना जांच प्रतिवेदन. 24 का है ना,
हाँ, Jharkhand.
18/9/24.
Inquiry report is of 22.
Inquiry report is
Yes.
22. Yes, please. Where is the
Inquiry
finding?
report says that he has worked beyond the.
Show me where is the finding.
It is the finding of the labor code
The labor code.
वो बाद में पहले
Lord,
ये-
I'm reading from the judge. पैराग्राफ 2 समिति मामले में समस्त पहलुओं की जांच एवं दोषी व्यक्तियों को चिन्हित करते हुए अपना जांच प्रतिवेदन सभी संबंधित अभिलेखों से वास्तव्य मंतव्य और अनुशंसा के साथ 7 दिनों के अध्यक्ष पर ऊर्जा समर्पित करेंगे. It has been pointed out that the workman has worked more than what the law permits. The chairman of Jharkhand Urja Nigam Limited is directed to make an inquiry and launch criminal case against the person who has taken work from the concerned workman against the law and submitted it for this. This was the order of the court. Finally, it was found that he worked beyond the.
दिनांक 10/2/2020 को पाया गया कि लगातार 16 घंटा का ओवरटाइम किया गया,
That was found in it.
जो श्रम कानूनों का पूर्णतः
उल्लंघन
उल्लंघन है. This is your inquiry report
Okay,
done
right.
subsequently. Where is the impugned order? This the same thing is there in the impugned order?
Yes. But the
Then make the payment.
but the labor court will not
Labor
exceed
court has given finding that admittedly respondents have taken work of 7,432 hours overtime. And now they are saying that as per the Factory Act, the overtime allowance only can be paid up to 950 hours, because in 1 year no one can be
that we have paid.
take overtime
Now you
for.
tell us what is the perversity in the order?
There is
Not the
आप बैठ जाइए ना.
labor court will not have exceeded beyond the provision of section 33C.
Okay.
Not the quantum will not the labor court has fixed will not without making any proper inquiry whether no a person is appointed to ascertain the quantum of the will not the amount, and the labor court will not have fixed it will not.
Did you file your WS?
W is way.
So the period for which he had worked stood admitted.
It will be admitted.
We admit. Now if you admit the period for which they have worked, then quantification is just a matter of calculation, which the labor court has done. Right.
57,000 we have already paid as per the will not the.
We do not know whatever you have paid. Whatever you have paid will be adjusted and rest will be paid through execution. We are not here to execute the award. तो जितना मिल गया है वो ठीक है, जो बाकी है एग्जीक्यूशन केस फाइल करके रिकवर करेंगे, यहाँ से ऑर्डर ठीक है.
they have challenged that award.
We have
That's it. We
challenged
will
the award,
see
but
that
execution
award is
case
perfectly all right. There is no error in that. Subsequently, also they have confirmed. WPL number 1790 of 2018. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner, while assailing the order dated 7/7/2017, passed in NJ case number 4 of 2014, has submitted that the learned Labour Court Ranchi has exceeded its jurisdiction while quantifying the amount payable to the respondent for hours of overtime. He submits that as per the provision of the office order number 451 dated 19/1/1995, the maximum overtime was revised to 60 hours in a quarter, and consequently an amount of rupees 58,684 was paid on account of 950 hours. The learned counsel submits that in such circumstances, the payment of overtime beyond 950 hours that is amounting to rupees 58,684 could not have been awarded by the learned.
That we are saying that the 4 lakhs are an odd figure which the court has calculated. Not one prayer million more. Not under section 33. Not where there is a dispute of the amount. The labor court should not have entertained the petition.
Okay, the learned counsel has submitted that apart from the aforesaid, the quantification of rupees 4,17,474.87 is not in accordance with law, as the computation has not been mentioned in the imputed award.
Yeah, where there is a dispute of the quantum, under section 33.
He has also submitted that under section 33C2, the dispute regarding quantum of amount to be payable could not have been adjudicated by the learned labour court, and the same ought to have been raised by the respondent by raising an industrial dispute. The learned counsel has also submitted that pursuant to order dated
17.
17/10/22, a complaint was made by the petitioner to the concerned police station regarding taking of overtime work more than permissible limit under the provisions of Factories Act, and a supplementary affidavit has been filed in this case dated 18/9/2020. He submits that such action was taken as back as in the year 2022, but the FIR was not registered. The learned counsel has also referred to the inquiry report which was preceded, the inquiry report which was done by the, pursuant to the inquiry done by the petitioner, wherein he submits that it was found that on 10/2/2000, the respondent was made to work 16 hours, continuous 16 hours overtime, which was in violation of labour laws. The learned counsel, appearing on behalf of the respondent Workman, has submitted that the learned labour court has passed the order within its competence under the provisions of section 33C2 of Industrial Disputes Act. He submits that the before the learned labour court, the wages were required to be, there was a claim for overtime hours of work to the extent of 7,432, and the only ground raised by the petitioner was that as per their office order dated 19/1/1995, overtime could be to the extent of 60 hours in a quarter, and an amount of rupees 58,684 was payable for overtime of 950 hours. Calculator दीजिए. Calculator दीजिए. Yes.
Payment was made for 57,400.
Just a minute. How much was paid?
57,400 on the head of overtime allowance, and 1,264 as a transport allowance.
So that is not concerned, right?
So, on the account of overtime 57,400.
The Learned Counsel submits that an amount of rupees 57,400 was paid on account of overtime allowance, and the amount of rupees 1,264 was on account of travelling allowance.
Traveling. Total 58,660.
Total 58,680.
664.
664, ये 584 लिखा हुआ ऑर्डर में 494. ऐसे कुछ भी कहीं से मत बोला करिए, अवार्ड से दिखाइए.
I am saying from the order of the department, payment order.
अवार्ड से दिखाइए ना. अवार्ड में एक एडजुडिकेशन होने के बाद क्या नया कहानी आप सुनाइए. सब मत लिखिए. इस ये लिखिएगा, द काउंसिल फॉर द रिस्पोंडेंट हैज सबमिटेड दैट it was stated before the court that an amount of rupees 50,100 was paid on account of overtime allowance, but the remaining was not paid. He submits that the amount has been quantified based on rate per hour. Which, and the learned court has quantified the amount at rupees 417,474
Deducting data.
after deducting the amount already paid. After hearing the learned counsel for the state has submitted that an FIR has already been registered bearing Kamdara PS case number 45 of 2024 dated 27/8/2024.
27/9.
Sorry, 27/9/2024 under section 374/34 of Indian Penal Code, read with section 59 of the Factories Act 1948 and section 14 of Minimum Wages Act 1948, and the investigation is under progress. However, she has no instruction as to why there was delay in instituting the case. The fact remains that case has been instituted and investigation is under progress. Okay. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the respondent had filed an application for payment of dues amounting to rupees 4,17,474.87 on account of overtime allowance with interest thereon. Computation कहाँ है आपका? They have not annexed it.
We have not filed.
They have not filed anything. They
All
never
right.
put it.
It was the case of the petitioner, or the case of the respondent, that he joined the post of fitter grade 2 on 12/4/1968 and superannuated on 1/2/2005. And was ordered to work overtime from January 1995 to May 1995, from August 1995 to October 1995, from December 1995 to March 2001, and May 2002 to January 2005. After superannuation from service on 1/2/2005, the petitioner made payment of retirement dues except overtime allowance for the period, and as per his calculation, the total amount of overtime allowance came to rupees 4,74,84,87. He represented before the authority, but no payment was made. Consequently, he filed a petition being WPS number 4140 of 2008, and he was directed to make fresh representation to the authority. And consequently, an amount of rupees 57,400 was paid on account of overtime allowance for 950 hours against the claim of 7432 hours by the petitioner, by the respondent. The claim was certified by Assistant Executive Engineer Kamdara Gumla. Being agreed by the nominal payment of rupees 57,400, he filed another petition before this court, which was registered as WPS number 5951 of 2009, which was withdrawn on 20/4/2010 with the liberty to approach the respondents or under Industrial Disputes Act before appropriate forum. As a sequel to the aforesaid, he filed a letter number 971 dated 28/8/2009 before the General Manager, Company Engineer, stating that the petitioner was made to work overtime, otherwise he would have been charged for disobedience, and prayed for release of amount of rupees 4,17,474.87 with interest. The aforesaid documents were duly annexed along with the petition filed under section 33-3-2 of the Industrial Disputes Act, which was filed by the petitioner upon notice, which was filed by the respondent, upon notice the petitioner appeared, filed show cause, and stated that the petitioner retired on 1/2/2015. It was stated that all retirement benefits, including overtime for 950 hours, amounting to rupees 57,416 was paid. And it was asserted by the petitioner before the Learned Labour Court that as per Board's letter number 162 dated 5/8/1993 and Board's letter office order number 451 dated 9/1/1995 and letter number 81 dated 13/4/1999, the amount of 950 hours of overtime was paid. And asserted that the claim for payment of 7,432 hours was unjustified and baseless. The circulars / office orders of the board were filed before the Labour Court, which was annexed. It has also been recorded in the impugned order that the original employee, namely Satyanarayan Singh, had expired on 15/3/2015, and his legal years were added pursuant to by order dated 22/5/2015. The Learned Labour Court framed the following issues for consideration. Para 5 the respondent examined himself as witness number 1 and additionally another witness was also examined and certain documents were also filed which were not marked exhibit. On the other hand, the petitioner did not adduce any oral evidence. The Learned Court recorded that on behalf of the applicant, 2 witnesses were examined. Who had supported the case of the applicant, and the witness was discharged without cross-examination, and no one turned up on behalf of the petitioner to cross-examine. Both the witnesses were not cross-examined and were accordingly discharged. The learned court recorded that there was no denial of the claim of the applicant. The witnesses were also not cross-examined. Consequently, the learned court quantified the amount for the learned court held that there was no specific denial by the employer with regard to the overtime claimed, and there was no denial of liability, and ultimately held that an amount of rupees 4,17,474.87 was payable and passed the order. The grievance of the, considering the objective facts, this court finds that the period of overtime hours of 7432 was duly proved from the side of the workman. It was also placed on record that for 950 hours, the payable amount was rupees 58,684. It also appears that the petitioner, the applicant had not only furnished the period of hours but also the quantum of claim. Once the period of hours was not disputed and the witnesses who had appeared on behalf of the applicant were not cross-examined, even the quantum of claim stood admitted. Further, it is also important to note that for 950 hours, the amount payable as per the petitioner was 57,400. And consequently, per hour of overtime comes to around 60.42, rupees 60.42. And if the rate is taken into consideration, it is matching with the quantum of claim awarded by the learned court. This is over and above the fact that the witnesses having not been cross-examined, not only the hours of overtime, but also the quantum at claim stood admitted. The only ground which was taken by the petitioner was the maximum period of overtime allowance which could have been granted as per the circular. This court is of the considered view that overtime having been taken from the employee, having been proved, the petitioner cannot deny payment for the work done. The impugn order passed under section 33C2 was within the four corners of the provision of law, and the argument of the petitioner that the applicant ought to have, the learned court ought to have dismissed the petition and the applicant ought to have raised an industrial dispute is devoid of any merit. This court finds that there is no illegality or perversity in the impugned order. Accordingly, the petitioner is right to
Even the amount,
Sorry?
the interest will not be taken. The Labour Court has awarded 12%.
आपको बहस ही नहीं की है ना इंटरेस्ट पर, हम लोग का ऑर्डर है यहाँ पर, हम तो वही आश्चर्य करते हैं।
It is exorbitant.
एग्जॉर्बिटेंट के ग्राउंड पे नहीं, हम तो होल्ड कर दिए कि इंटरेस्ट दे ही नहीं सकता है PTC के लिए, आपको पता ही नहीं है ऑर्डर। We have, I will include it here. We have held it in this court. Mr. Amit, you are here. We are, yes. आपसे पूछो मिस्टर मेहता की जूनियर, आप ही आपका नाम ही भूल जाएंगे, क्या नाम है आपका? मनीष सर। 33C2 का वो ऑर्डर है जिसमें इंटरेस्ट नहीं पेमेंट कर सकते, दीजिए। अपना फेवर का चीज़ देखते ही नहीं है, हम तो वही सोचे कि अपने मन से हम क्या ही कर दें। There is a judgment passed by this court, which to the best of my knowledge has attained finality, कि 33C2 में computation करने के बाद इंटरेस्ट का अवार्ड नहीं हो सकता है, because it is payable by way of certificate proceedings. Certificate proceeding में statutory interest 6% रहता है।
No, they have not paid any interest. They have paid after the award. If not paid, then the interest.
Interest not paid.
If not paid, no.
If not
Within 2 months.
within two, if not paid within two months.
आप जजमेंट देख लीजिए वो।
Billing which?
एक सेकेंड आप जजमेंट देख लीजिए प्लीज। कोर्ट का जजमेंट है ना, इनकंसिस्टेंट ऑर्डर नहीं होगा, देख लीजिए। देखिए ऑर्डर हम लिखा दिए, इंटरेस्ट पर हम 2 शब्द लिखाएंगे, आप जरा देख लीजिए जस्ट 10 मिनट्स बाद। आप भी देख लीजिए वो ऑर्डर, आप ही को प्लेस करना होगा, साथ में बैठे।
Item 2 WPL 1935 of 2021.
केस का नंबर बताएं जरा, केस का नंबर, केस नंबर 6969 ऑफ 2017 WPL, ये ऑर्डर निकल 6967 ऑफ 2017। यस
Yes, ma'am. So there is to quash the orders passed by the controlling authority and the appellate authority under the payment of gratuity. The respondent was the general manager of Central Workman Limited. On 23rd of December 15, he was issued a charge sheet. However, he retired on 31st of December 16.
वेयर इज द रेस्पोंडेंट?
He was directed to my counter.
It's okay, by way of last chance हो गया। Where is none on the last date also, nobody had appeared. Is somebody appearing?
हाँ, दीपक कुमार दुबे से।
DK दुबे। कौन मिस्टर दुबे प्रैक्टिस छोड़ दिए हैं?
नहीं, ये दीपक दुबे राजेंद्र कृष्णा सर के साथ।
नहीं, हमको याद नहीं। सम मिस्टर दुबे।
अच्छा, हाँ, विजय कांत।
विजय का। Where is Mr. DK दुबे? वकालतनामा फाइल है उनका? Are you there in this case?
I talked to him, he said that he is out of station. He could not mark this.
ऐसा invitation card तो कोई नहीं भेजता होगा.
Yeah, just now I have
We do not want any ex parte orders, DFD. क्या फायदा है? इसको करने से क्या फायदा? We are here to adjudicate the cases, no? जब इतना पूछती है तो ये भी बता दीजिए कि कब उनका दर्शन होगा हम लोग को. पूछ लीजिए कौन सा डेट उनको पसंद है उसी दिन. ये देख लीजिए, सॉफ्ट कॉपी में पढ़ने की बजाय हार्ड कॉपी में देखिए. देखिए WPL number 1935 of 2021. Counsel for the petitioner is present. Nobody appears on behalf of the respondent. However, Mr. नाम बताएं अपना नाम बताइए. अपना Mr. Aditya Raman has informed this court upon instruction from the counsel for the respondent that he is out of station for his personal reason and has made a prayer to adjourn the case
after Diwali. Any date.
to any date after Deepavali vacation.
20.
At Wednesday,
Yes.
No, there is no school.
Yeah, Wednesday.
at Wednesday, pose this case under the heading for final disposal on 13th.
Make it 20. तुरंत छुट्टी के बाद रहेंगे नाइट पे.
तो 13th
So that no more adjournment
क्या
can.
मतलब है?
13th कोर्ट बंद रहेगा.
और 13 कोर्ट बंद रहेगा. 20 तारीख भी कोर्ट बंद रहेगा.
नहीं नहीं 20 को.
रांची के लिए
20 तारीख.
इलेक्शन.
20 तारीख. 20th. You prepare your synopsis. उनको भी बोल देंगे तो अपना synopsis बना लें.
Item 3 WPS 5114 of 2020.
Yes, petitioner. Not today. पिछली बार not today हो चुका है. कितना बार not today? Yes. नहीं, आपके एडवोकेट हमेशा आउट ऑफ रांची रहते हैं. At his instance, the case was posted today. Mr. Manoj Kumar Ram, advocate on record. कौन है ये? ये समय से the arguing counsel is not available. उस दिन Mr. Manoj Kumar Ram appear हुए थे. कौन है? आप हैं? अब बहस करिए, हमें एडजर्न नहीं कर सकते. कुछ नहीं है आपके केस में. सॉरी. ठीक है, कल कर दे. कौन सा साल में कर दें? आप कल कोर्ट नहीं आ रहे हैं? आप आइए. ऐसे नहीं है ना, एक फाइल को हमको दोबारा नहीं पढ़ना चाहते हैं. Why should I read one file again? I spent time reading it. You come tomorrow. WPS number 5114 of 2021. Counsel for the petitioner, Mr. नाम बताइए. Abhishek Charan. Prays for adjournment on behalf of advocate on record Mr. Manoj Kumar Ram and he submits that the matter be posted tomorrow. Although by the order dated 14/10/2024, the matter was listed today with a clear indication that no further adjournment will be granted. However, for the ends of justice, the matter is directed to be posted tomorrow 10:30 बजे, 1 बजे, to be taken up at 1 o'clock. नहीं आइएगा तो भी हम लोग ऑर्डर कर देंगे on the if the counsel for the petitioner does not appear tomorrow, the case will be decided on the basis of materials available on record, and no further adjournment will be granted. देखिए, बताइए क्या बोलना है?
In the instant case, no interest was awarded under section 33C2. The interest is only if he fails to pay within.
That's right. That is the normal order. 33C2 में computation होता है. If he does not pay within time, you have an option to institute a certificate case. And in the certificate case, there is a provision for payment of statutory interest. Once the certificate is drawn, then 6% interest जहाँ तक हमको ध्यान है 6% interest लगता है, ठीक है? तो अगर सर्टिफिकेट केस में 6% इंटरेस्ट लगेगा तो इंटरेस्ट के ऊपर इंटरेस्ट कैसे कैलकुलेशन, राइट? ऊपर ही लिख दीजिएगा, लाइए ऑर्डर पढ़ते बढ़ते नहीं है. हाँ, मर्सी पे कोई ऑर्डर नहीं होता है, लॉ पे ऑर्डर होता है. The learned counsel for the petitioner has also referred to a judgment passed by this court in WPL number 6969 of 2017, decided on 19/6/2023, and has submitted that the award of interest to the extent of the award of interest by the learned labour court is beyond jurisdiction, and same is fit to be set aside. The counsel for the respondent has submitted that there is no direction to pay interest on the amount. Rather, on account of non-payment, there is a direction to pay interest at the rate of 12%. Finding में लिखिएगा. So far as the direction to pay interest is concerned, the same is squarely covered by the judgment passed by this court in WPL number 6969 of 2017, dated 19/6/2023, and accordingly, the impugned order directing payment of interest is set aside. In case the computed amount is sought to be recovered through any certificate proceeding, the statutory interest as applicable to the certificate proceedings will be payable in accordance with. डाल दीजिए. थोड़ा इसमें मॉडिफिकेशन होगा, वो रेलेवेंट पोर्शन हम खोल देंगे. आपका तो हो गया ना रिलीफ, काफी रिलीफ हो गया. आप तो पढ़ते ही नहीं है तो क्या ही करें हम लोग. इसको कई केस में हम लोग फॉलो भी किए हैं. अभी तक आई हैव नॉट कम अक्रॉस एनी कॉन्ट्ररी व्यू ऑफ डिविजन बेंच और ऑफ ऑनरेबल सुप्रीम.
इसको फिर डिस्पोज ऑफ करेंगे या डिसमिस
डिस्पोजल कर दीजिए. डिस्पोजल, हाँ डिस्पोजल करेंगे.
Item 4 WPL 3961 of 2023.
Where is the petitioner? Yes, are you there?
We are also
Rejected. Rejected last time भी इसी ग्राउंड पे टाइम. इसमें नॉट टुडे नहीं होगा. काउंसिल को बुला के लेंगे जाएंगे.
then maybe put them up tomorrow also.
He has not come to the court.
Some document is required. As per
No
instruction
document is required. Limitation में क्या document is required?
As per instruction of my senior Euro.
Who is your senior?
Mr. Omkar Nattiwari also.
He has argued this case substantially on the last date. Last date का वीडियो निकालिए, आपको पता चल जाएगा क्या क्या
Maybe
मैच.
put up, maybe after second time.
Second half. चल.
Under heading for fresh filing, item 5 WPL 5555 of 2024.
My lord, the impugned order is against the rejection of my waiver application for pre-deposit. My lord, if your lordship, her ladyship may kindly see. My Lord, against the application for partial rejection of my application for waiver of pre-deposit in terms of section 7(o) of the Employees Provident Fund Act, my Lord, Her Ladyship. Kindly, my Lord, take the impugn order itself. My Lord, on a plain reading of the impugn order itself would reveal that neither of the considerations of prima facie case balance of convenience and, my Lord, irreparable loss and injury have been considered.
What was your plea regarding
Yes.
balance of convenience
Yes,
and
kindly,
prima
my Lord,
facie
application
case?
for waiver is, my Lord, at Annexure 5, page 71. And page 73 is the plea which I have taken.
It is at page number annexure 5/1 at page 76.
But that's a stay application,
Yes.
and my waiver application is also preceding that. Annexure 5, page 71 is my waiver application.
Let me just have a look. Let me just see the provision of law first.
Yes, I have also quoted that, but Ladyship,
7(o).
7(o), yes, it has been quoted in my petition. But well, I just showed from the book.
Yes, yes. There is a requirement of pre-deposit of the entire amount,
No.
and there is a provision for waiver
Yes,
or
there is
reduction of the amount.
there is a requirement of pre-deposit of 75% of the amount,
Yes.
and a provision for waiver is there that in cases the pre-deposit may be waived.
For reasons to be recorded.
Yes, for reasons to be recorded in writing. Now, my Lord, may I straight away, before your Ladyship, my Lord, refer to some judgments on this, my Lord.
No, you just show me your ground. What
Yes.
ground have you taken?
Kindly come to page
The
7.
provision is so clear
Yes,
that
it
no
has to
judgment
be.
is required. It has to be reason,
It has to be
but
reasoned.
you have to show that what was your
Correct.
ground.
So, my Lord, I
is.
just show my grounds. First, my Lord, my Annexure 5, page 71, my Lord, is my application for waiver. And, my Lord, may kindly straight away come to para 1 itself first, because this is my case which I am setting up on a prima facie case. Para 1, that the appellant has preferred an accompanying appeal against the illegal and arbitrary order bearing number so and so, passed by so and so, under section 7(a) of the Employees Provident Fund and Miscellaneous Provision Act, whereby the respondent authorities have erroneously and without any basis and without fixing the liabilities of the contractor, as well as without determination of the number of employees workmen, held that it should be held, my Lord, that the appellant is liable for rupees so and so as EPF and allied dues for the period so and so, so and so. So this is my ground number 1 itself on prima facie case, that neither the contractors have been examined.
The liability is joint and several.
Well, liability is joint and several, but my Lord, the law says, I'll show the law.
We
my
will
Lord.
not enter into the merits because the impugned order does not have a reason.
Exactly, my Lord. Now, if I come straight
Yes,
away,
what
my
do
Lord.
you say?
My Lord, one judgment, my Lord, you will also see 2 judgments, my Lord, latest judgments of 2024. Of course, my Lord, I have annexed that your Lordship are aware of the principles. My Lord, any case where there is a stay which is to be dealt with, the three ingredients have to be discussed and decided. And my Lord, that is one 2024 I have annexed, and my Lord, another judgment of the Supreme Court.
You see, this is not a matter of stay. It's a matter of waiver of pre-deposit.
Waiver also, same principles have been upheld. If your Lordship, Ladyship wants, I
We'll
just
see
pass
that.
on.
Let us see the impugned order
Yes,
first.
impugn order is at page 80.
Yes, respondent, just have a look at the impugned order. Is there any reason assigned? As per the statute, a reason was to be given.
His case melody, I just place it.
We will not enter into the merits.
I
As
know
per
what
the
it-
statute,
Yes.
reason is to be assigned.
Appeal is admitted.
Yes,
Severe
yes. There is no
and condition is imposed so far as the stay is concerned.
No, just a moment.
If I just press
Just,
it.
you
Yes.
see, his petition for waiver has been disposed of.
His appeal is, my lord, precondition was appeal, pre-deposit. Appeal is admitted so far as what I have gone through the record. So precondition has not been applied for his case, so there is absolutely waiver, no waiver. His appeal is admitted.
The
What
under what provision of law the impugned order has been passed? Kindly tell me the provision of law under which impugned order has been passed.
If I just
Is it an order under section 7(o)?
not, it is not an order under 7. It
Let's have
says,
a
my
look
lord,
at it. Let's have a look at it.
yes, that is what I
On
would
the
say.
face
A
of
page
it.
order, my lord, may kindly come to page 80.
Page
80.
8. Yes, annexure 6.
Annexure 6.
Okay.
May
Can you read it?
I please?
It's just
So,
2 page
so,
order.
my lord, 2 page orders. Mr. Sinha, Arun Kumar Sinha, Company Secretary, Constitute so and so, appeared before the tribunal and prayed for admission of the appeal. Mr. Nitish Sahai for respondent appeared for filing of Radhanawa, Mr. Arun Kumar Sinha, Constitute so and so, act of the assessment period and the provident fund so and so has been assessed against the establishment. Mr. Sinha moved an application praying for exempting the appellant from depositing under 7(o) of the Act and here the appeal on merit urgently. He also prayed for the stay of operation of the impugned order passed by Regional Provident Fund Commissioner. Mr. Nitish Sahai, so and so, the respondent raised objection and submitted that appellant does not deserve waiver of so and so. The appeal against order so and so has been filed, which is within time laid down under Rule 7(2) of the. This appeal is accordingly admitted. So 7(o) occasion was not there. Similar matter was taken up. So 7(o), the court has not asked
What
him
is
to
the meaning of waiver?
that.
What is the meaning of waiver of pre-deposit?
That he has not been called upon to deposit any.
Therefore, that amounts to stay only. It's one and the same thing.
In my
When
sense,
there is an impugned order
yes.
subject to an appeal, as per the appeal, 75% is to be deposited. If there is an order of waiver, it means waiver of maybe to the extent of 50% or 20% or 30%, right? There is automatic stay so far as the rest of them are. Suppose there is an order of deposit of 30%, there is an automatic stay for remaining 70%.
That,
You
that,
just
that
show
is
me the reason on this.
Yes, I am just coming matter and one judgment of the court and bench.
Yes.
I will consider the submissions by learned advocate for a respondent. The memo of appeal and impugned order. I am of the considered view that it would be just and appropriate to direct the appellant to deposit 30% of the dues for the purpose of entertaining the appeal by this tribunal. The appellant is directed to deposit the said amount within 3 weeks from the date of order. There shall be stay of operation of the impugned order dated so and so if the appellant deposit 30%
Fair enough.
in favor of the. So 30% he was called upon to deposit.
That's right. Where is the reason to deposit 30% also? And where is the reason to waive 70% also? You see, both the things are not there. The statute provides a reason. I will fix a date here. You pass a fresh order. What's the big deal about it? It's special non-speaking.
Coordinate bench order merit on the point of the stay that if Mellor will have a kindness to it. This is just
What is it?
This is also a case where 20% was the order that was passed for depositor for the purpose of the stay and that the court has taken.
The provision of law has not been placed. There is a statute.
So there was also a case of 7.
We do not know.
But
We
this
do
is
not
my
place-
submission.
No, we
This
will
is-
deal with it. Don't worry
Then
about
we
it.
will file one affidavit to this. It is coming for the first time.
What affidavit you need to file? On the face of it, you see, please appreciate. You are concerned with the money,
Yes.
right?
Yes.
On the face of it, if it is non-speaking, you tell me I'll fix a date. Let him hear him,
Minor.
let him pass an order, a reasoned order. What's the big deal about it? He will have a space for only 15-20 days or maximum 1 month.
I go down, madam.
Simple. Done. अपना इंटरेस्ट थोड़ा ध्यान में रखिए उसके बाद रीजन ऑर्डर होने
Actually, these
And you
quasi-judicial
see-
authorities are not trained officers in the judicial side. This is the problem. He should not have admitted. Now he has admitted, then he says that you deposit 30%.
No. It is a condition for admission.
He has admitted.
No.
That is
You just see.
you-
No. Dues under section 7 for the purposes of entertaining the appeal by the
My lord
tribunal.
will kindly come to first page.
फर्स्ट पेज सेकंड पेज में कॉन्फ्लिक्ट है तो हम लोग कर ही क्या सकते
This appeal is accordingly admitted.
हैं? आप पेज नंबर 81 नहीं पढ़ेंगे?
आप उसको एडमिट कर लिए तो तुमको एंटरटेन
आप
करना ही
पेज
होगा.
नंबर 8
Yes, that is there, but he should not have written admitted. It will be admitted subject to
इनको
deposit.
ट्रेन करने का काम भी किसका है?
This is off and on we are facing these difficulties.
कोई बात नहीं, एक आध ऑर्डर सही से हो जाएगा तो उन लोग भी सीख
It will
जाएंगे.
sit to the train.
अब बहुत हार्श हो जाता है ना किसी के लिए. And you see one more thing, there is a silver lining for you. It may come up to 70%.
Yes.
We do not
It is
know what
open-ended. It is open-ended.
we do not know what is going to come
Yes.
ultimately. We do not know. So उसमें हम लोग को कुछ बोलने की जरूरत नहीं है. The court will decide. I don't want to pronounce anything more. WPL number 5555 of 2024 heard the learned counsel for the parties. The learned counsel for the petitioner has referred to the impugned order dated 22/8/2024 as contained in Annexure 6 and has submitted that the order under section 7 within bracket 7O of the Employees Provident Fund and Miscellaneous Provisions Act 1952 has been passed, asking the petitioner to deposit 30% of the dues assessed under section 7 capital A of the Aforesaid Act for the purposes of entertaining the appeal without assigning any reason. The learned counsel submits that the petitioner had applied for full waiver to the extent of
Full
for full waiver, but the order impugned is contrary to the provision of section 7O, wherein there is a clear provision that for entertaining an appeal, 75% of the amount of dues as determined under section 7A is to be deposited, and the tribunal, for the reasons to be recorded in writing, waive or reduce the amount of deposit under this section. So he submits that the statutory mandate of giving reasons in writing for waiver or reducing the amount has not been given. He submits that had the tribunal applied its judicial mind on the petition, the petitioner was entitled for full waiver. The learned counsel appearing on behalf of the respondent has, while opposing the prayer, has relied upon the order passed by this court in the WPL number 4984 of 2024, decided on 13/9/2024, and has submitted that in the said case there was a direction to deposit 20% for the purposes of grant of stay by the presiding officer Labour Court, but this court refused to entertain the challenge to such an order. He has also submitted that by the impugned order 70 कितना percent बच गया?
60-40% उसमें
30% waiver को 45% बचा.
45% has been waived in favor of the petitioner. Right? 45% waive हो गया ना?
हाँ. This is not my submission.
अच्छा, okay, आप submission अपन.
My submission is that his appeal is admitted and condition precedent for stay has been
Okay.
30%.
The learned counsel has submitted that the appeal has already been admitted and the condition has been imposed for deposit of 30% as by way of stay. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that an order under section 7A was passed against the petitioner and the same was subject matter of challenge before the Central Government Industrial Tribunal number 2 Dhanbad, which was numbered as TPFA case number 29 of 2024. The petitioner filed a petition for waiver of deposit under section 7O, and by it order dated 22/8/2024, the petitioner was directed to deposit ₹30% of the dues assessed under section 7 capital A of the Act for the purpose of entertaining the appeal by the party. The aforesaid finding of the learned court is quoted as under. इसको quote ही कर दीजिए. upon perusal of the petitioner was directed to deposit the said amount within a period of 3 weeks from the date of the order. Upon perusal of the impugned order, this court finds that the first page, and this court finds that no reason has been assigned to limit, no reason has been assigned while asking the petitioner to deposit rupees 30% of the dues assessed under Section 7 capital A of the Act for the purposes of entertaining the appeal, although the petitioner had claimed for full waiver, and consequently the claim of the petitioner for full waiver has been declined, and waiver to the extent of 45% of the assessed amount has been granted. This court is of the considered view, the provision of Section 7(o) is quoted as under. There is a statutory mandate to deposit 75% of the amount as determined under Section 7(a) of the Act of 1952, and the tribunal has been empowered to waive or reduce the amount of deposit, and for such purpose a reason is to be recorded in writing. The impugned order dated 22/8/2024 is bereft of any reason. The learned tribunal has simply directed the petitioner to deposit 30% of the dues assessed under Section 7(a) as a condition for entertaining the appeal. This court is of the considered view that the order has been essentially passed under Section 7(o) of the Act of 1952, and it is not an order on a simple stay application. And accordingly, the order dated 22/8/2024 is contrary to the provision of law, and therefore the same cannot be sustained in the eyes of law. So far as the order passed in WPL number 4982 of 2024, dated 13/9/2024 is concerned, upon perusal of the same, it appears that the quantification, the demand involved in the same case was under Section 7(q) and 14(b) of the aforesaid Act of 1952, and the perusal of Section 7(o) revealed that the same is applicable for determination of dues under Section 7 capital A. In the aforesaid facts and circumstances, considering the mandatory provision of law under Section 7(o) to assign reason while dealing with an application for waiver under regarding pre-deposit under Section 7(a), this court is of the view that impugned order, the order dated 13/9/24 passing WPL number 4982 of 2024 does not apply to the facts of this case, and accordingly the impugned order dated 22/8/2024 is hereby set aside.
The next date fixed is on 18 December because this tribunal comes operated from Asansol.
At this, the counsel for the petitioner has submitted that the next date fixed in the matter is on 18th of December. Consequently, the parties are directed to appear before the tribunal on 18th of December, and upon their appearance, a fresh order will be passed on the petition filed under Section 7(o) of the aforesaid Act of 1952, after granting an opportunity of hearing to the parties within a period of 1 week from the date from 18th of December. Accordingly, that should be sufficient.
Yes, yes.
ये 14B का 14B का ऑर्डर है 7Q 14B
There also 7I appeal is there.
7I अपील में तो ये अप्लाई नहीं करता ना 7A है you have
7A,
seen
7A का
just a
7I.
moment
Yes.
7A 7O is relating only to 7A
And there are judgments, or one judgment of the Supreme Court which says the principles of 7O may apply for stay, but there is no waiver in 7 so far as 7O is concerned.
उसकी जरूरत किसी और केस में
हाँ पढ़े किसी और भी पढ़े.
देखिए रीजन these are procedural things इसको स्ट्रीमलाइन करना बहुत जरूरी है इस तरह के मैटर्स तो आने ही नहीं चाहिए
That is, we are confronting with this situation. On revenue side also
तो
we
आप
are.
जब वहाँ अपियर होते हैं तो
हाँ,
बोलिए
मैं
ये
appear
रीजन आप रीजन ऑर्डर फाइल करिए
I
पास
don't
करिए
appear in those trials.
But your
मतलब
colleague
आपका
appears.
अथॉरिटी जब appear
Authorities-
होता है तो उनको बोलिए कि उनको प्रोविजन दिखाने इस तरह के मैटर्स में अननेसेसरीली आपका रिकवरी दिसंबर तक रुक गया ना क्या फायदा हुआ आपको रेवेन्यू का आपको ध्यान ही होश ही नहीं है इतना अमाउंट है बड़ा जॉइंट एंड सेवरल लायबिलिटी है इसके बियॉन्ड हम बोल
Now 7.3A भी है. What he says that employees are not quantified. 7.3A इनका
मेरिट में हम थोड़ी डिसाइड करते
Item 6 WPL 5568 of 2024.
यस petitioner
Yes. This repetition has been filed.
School. why school agreed
Because the respondent number 3 has filed an application under Gratuity Act for giving gratuity.
so
Here, the order has been passed without giving opportunity of hearing to the petitioner. Earlier also it was done before, for the same time at the time of evidence reversal, and accordingly we have preferred one WPL number 3992/2021, in which it was ordered in our favor to and opportunity was given. Thereafter again while passing of the final order also again the same situation has been done. That's why
from where do you say that
I said my prayer is itself the same. Whereby the respondent number 2 has allowed the application of the respondent number 3 without following the principle of natural justice and also without
वादी की ओर से प्रस्तुत बहस के आलोक में
page 18
वादी
is
कौन है?
relevant. Page
वादी
18
कौन
is
है?
relevant here also. Kindly see page 18.
yes
Before this second para 4 line ऊपर तदनुसार दिनांक 2/12/2023 को वादी पक्ष की ओर से लिखित बहस दाखिल किया गया परंतु दिनांक इतना को प्रतिवादी के विज्ञान अधिवक्ता द्वारा बतलाया गया कि उन्हें इस वाद में लिखित बहस दाखिल नहीं करना है. इस प्रकार वाद सुनवाई की प्रक्रिया समाप्त हो जाने के फलस्वरूप वाद आदेश रखा जाता है. ये उसी दिन आदेश पे रख दिए विदाउट हियरिंग.
आदेश पे रखा जाता
हाँ और उसके बाद फिर ये ऑर्डर आ गया. तो उसका सुनवाई तो कम से अच्छा लिखित बहस दे रहे थे एटलीस्ट सुनवाई तो सुनवाई नहीं किया उसी दिन समाप्त कर दिया उसके बाद आदेश पे रख दिया और ये आदेश पे रख दिया.
है ये वाद सुनवाई के दौरान भी जो लिखा हुआ है इसका क्या करना है
when this date was fixed here also कि रिटन सबमिशन देना था तो रिटन सबमिशन पिटिशनर के द्वारा दिया गया जो वहाँ पे पिटिशन रिस्पॉन्ड नंबर 3 थी और हमारे तरफ से इसमें लिखा हुआ है कि बोला गया कि हम रिटन सबमिशन नहीं देंगे लेकिन सुनवाई लेकिन उस दिन नहीं
ये
हुआ.
उसका नेक्स्ट लाइन पढ़िए ना
तो उसके बाद ही इस प्रकार वाद सुनवाई की प्रक्रिया समाप्त
उसके बाद पढ़िए वाद सुनवाई के दौरान स्पष्ट परिलक्षित इसका क्या
on
करें
this date only is referring
तो क्यों नहीं कर सकता उस दिन हियरिंग आपको रिटन सबमिशन नहीं फाइल करना है
तो हियरिंग नहीं हुआ उस
ये
दिन
तो लिखा है वाद सुनवाई के दौरान
बट फैक्ट इज दैट कि उस दिन सुनवाई नहीं हुआ वो वाद को आदेश पे रख दिया
नहीं
गया
आप अपना अपील
एटलीस्ट नोटिस में भी गिवन
नोटिस किस लिए क्या चीज के लिए नोटिस करेंगे बताइए
ये इसको क्वेश्चन कर रिमांड बैक कर देते हैं.
रिमांड
This is
बैक
my
कैसे
honest-
ऐसे रिमांड होता है क्या ऐसे रिमांड नहीं होता इसको
क्योंकि
ना, आसान नहीं
earlier
है
also
ऐसे
कि हमको
remand
एविडेंस के लिए था डेट फिक्स था उस दिन भी हमको करने नहीं दिया कि जिसके एनेक्शन 2
इसका लास्ट पेज कहाँ है
ये
Where's the last
सप्लीमेंट्री में फाइल किया है क्योंकि वो पेज उसमें नहीं था सप्लीमेंट्री के थ्रू फाइल किया.
नहीं ऐसा कुछ नहीं जाइए अपना अपील करें इसमें तो लिखा हुआ है बात सुनवाई कहाँ लिखे हैं आप क्या व्हाट इज योर एवरमेंट इन द रेपुटेशन टेल अस व्हाट वाज द अर्लियर रेपुटेशन
Earlier repetition in that at the time of
one
evidence
opportunity will be granted
for cross examination of the That is for at the time of
Did you
evidence.
cross-examine?
Yes, Your Lordship. At that very moment, yeah, because after the passing of this order, before December,
Okay.
Annexure 2 है. And thereafter, Your Lordship, as stated in para 11, was proceeded and responded to again without granting opportunity of hearing to the petitioner has passed an imperial order dated 21/6/2020.
कहाँ लिखे हैं कि वो जो बात सुनवाई के दौरान लिखा है that is an error of record?
This submission.
Imperial order बिना
December.
पढ़े आप इस तरह से स्टेटमेंट नहीं बना सकते. कैसे हम लोग डिसाइड करेंगे? अपील फाइल करेंगे. Unnecessary.
Your Lordship, तो liberty में भी granted refer अपनी.
WPC number 8557 of 2024. Counsel for the parties are present. District petition has been filed for the following relief. Yes. The counsel for the, after some argument, the counsel for the petitioner seeks permission to withdraw this petition to avail the alternative remedy of appeal under the Payment of Gratuity Act.
Yes, sir.
The impugned order is dated 22/6/2024 and the writ petition has been filed on 22/8/2024. कितना टाइम है इसका पेमेंट ऑफ ग्रेजुटी में अपील का? The certified copy of the order was issued to the petitioner on 27/9.
Earlier it was given on 5/7/2024, but on that one
On
page.
5/7/24. कहाँ लिखा?
In the letter.
The certified copy of the impugned order was given to the petitioner on 5/7/2024.
60 days also.
है ना टाइम है ना इनके पास. The case has remained pending before this court from 22/8/2024. Counsel for the respondent has no serious objection to the prayer for withdrawal. He has submitted that the petitioner may avail his alternative remedy. Considering the submissions, this petition is dismissed as withdrawn. Liberty is reserved with the petitioner to avail the alternative remedy of appeal, statutory appeal within a period of 1 month. 1 महीना टाइम दे दिए हैं, लिमिटेशन का कहानी ऐसे खत्म हो गई. समझ आई बात? चलिए. बहुत स्ट्रिक्ट लिमिटेशन.
And that's why I'm going to submit
इसीलिए
that
इतना कहानी
limitation. So that
Under
1
heading,
महीना के अंदर फाइल करें.
under heading for admission, item 7 WPL 7059 of 2012.
Yes, petitioner.
Even you release from judgment.
Who is for the respondent? बिना respondent पे कैसे सुनेंगे? Who is for the respondent?
Mehta used to appear.
Where is Mr. Mehta? कितने सारे जूनियर्स हैं, उनको बुलाइए किसी. Earlier somebody, Mr. Vikas, Mr. Manish Kumar has appeared. Then
Earlier, Mr. Manuka Mehta had appeared.
Mr. Manish Kumar has also appeared in this case. Fresh वकालतनामा फाइल किया. देखिए तो Mr. Manish Kumar का नाम है. अच्छा हाँ. ये ऑर्डर जल्दी निकाल देंगे 1 महीना का ना. इसको तुरंत हमने कॉपरेट करना.
That वो छोटा सा है, बोला जाएगा थोड़ा.
अच्छा देखते हैं आने दीजिए. Yes, Mr. Manish, are you there to argue this case?
Yes, sir.
Ready? Yes.
Lord, respondent number 2 was appointed as apprentice development officer from Lord 15/4/1989
You have given it any list of dates?
लिस्ट ऑफ डेट्स में छोटा सा है सिनॉप्सिस में काम चल जाएगा नहीं बनाया था
ठीक है, synopsis.
2-3 डेट ही रेलिवेंट है
ठीक, बताइए.
15/4/89 Respondent number 2 was appointed as apprentice development officer. After the completion of training period, the respondent number 2 was appointed as professionally development officer on 14/1/1991. As per the terms and conditions of the appointment, the petitioner was initially put on probation for a period of 12 months from the date of joining duties. And the maximum as per terms of the appointment letter, maximum period of probation was 24 months. Extendable with the permission of the authorities of the corporation. During the probation period, the respondent number 2 was required to achieve certain business, appoint certain number of agents and all. These were the preconditions in the confirmation. The initial the probation period, the 1 year, it came to an end on 31/3/1992. The petitioner failed to achieve the target in terms of the appointment letter. He was given extension. Extended period also expired, but the petitioner failed to achieve the target. And finally, he was discharged from the service on 2/6/1992. 2/6/1992. So when he was discharged, he was on probation, and since he failed to fulfill the conditions as enumerated in the terms of appointment, so he was discharged. Now, my lord, 3-4 issues are involved in this writ petition, my lord. And I would like to address, my lord, the honourable court on the question of law. My lord, the first issue is that whether petitioner, my lord, the respondent number 2, being a development officer, will come within the purview of the Workman under the Industrial Disputes Act, number 1. The second issue is that whether the Industrial Disputes Act at all is applicable in the case as the service conditions of the respondent number 2 is governed by a statutory regulation. Number 3, that there was positive order confirming the petitioner in the service was required. That is settled. I will show from the judgment also. In terms of the appointment letter, a positive order was required to be passed for confirming the petitioner in the service. Admittedly, petitioner was not confirmed in the service after extended the period expired, and he was discharged from the service on the ground that he has failed to achieve the target. So whether the order can be said to be punitive, and whether any departmental proceeding etc. was required to be conducted in this case. The third issue which I will argue, that depends on the outcome of the first issue, because that goes to the very jurisdiction of the tribunal. Now, this issue with regard to the fact that respondent number 2 is not a workman, that was raised before the learned industrial tribunal. And if you will have a look, to order dated 3/5/2002, LCR was called for 3/5/2002 order passed by the tribunal. The tribunal specifically was raised that the claimant is not a workman under the Industrial Disputes Act.
3/5/2002.
3/5/2002. The tribunal has observed that this issue will be decided at the time of final disposal, and that has been decided. That issue has been decided in terms of in the award itself. I will show the relevant part of the award on this, how the tribunal has dealt with this issue. Have a look to page number 58 of my petition, written petition. And if you like to see the reference first, then I will refer to page number 50 in terms of reference. Milord, the first, the page number 50, Milord, agreed petition. Whether the action of the management of LICI of India Patna in terminating the services of Sri Umesh Prasad Chaudhary is legal and justified. If not, to what relief the workman is entitled. These are the terms of the reference. Kindly have a look at page number 58. The first issue, Milord, on which I am addressing this honorable group.
58.
58.
There is
58.
no page 58.
Milord, internal page 9 होगा वार्ड का, running page 58.
आपका रनिंग पेज पेज 36.
अच्छा तो वहाँ पर लगता है नंबरिंग गलत हो
हाँ, कोई
गया,
बात
कट की, ठीक है 36.
बताइए.
36 में देखा जाएगा सेकंड लास्ट पैराग्राफ. Issue was raised, Milord, then how the learned tribunal had discussed. Another law referred is a 1983 4 SCC 214, which Honorable Supreme Court laid down, Labour and Services Industrial Disputes Act 1947, Section 2S, Development Officer of LIC are workmen, designation or name of post, not decisive factor to be considered, Life Insurance Corporation of India, Staff Regulation 1960. Then next page, Milord, page 37. As per law laid down by the Honorable Supreme Court, the development officers are workmen. No domestic inquiry was conducted by the management before terminating the services of the concerned workmen, even on probation period. No report of the manager of so-and-so under whom the concerned workmen were working and probation development officer was invited by the management. The termination order was passed and dated. It also shows high headedness of the management. The concerned workman has worked for more than 240 days in a calendar year. Considering the above fact and law, I hold that the concerned workman is entitled to be reinstated in service with effect from 1/4/1992, which 50% back period. Now, Milord, why I refer Milord the earlier page, page 36. The learned tribunal has relied on Milord the judgment passed by the Honorable Supreme Court in 1983, volume 4, SCC 214, Milord. That is S.K. Burma case. I have given Milord a list of judgment along with the judgments. It is right. Milord, the judgment passed in S.K. Burma case, that is serial number 2, Milord. I am not referring, I am directly coming to Milord the next judgment, serial number 3.
No, that is a judgment which you need to refer.
Milord, उसको हम refer कर देंगे. Straight away, it has been Milord discussed and overruled by the Honorable Constitutional Bench in the next judgment, HR Adityan versus Sendoj India. Page number 18.
This judgment has been overruled.
Overruled. Yes. और उसके बाद भी जो है एक जजमेंट और है रिसेंट नहीं है, पुराना ही है, मुकेश कुमार त्रिपाठी. ये भी जजमेंट पेपर देखिए 2004 वॉल्यूम 8 SCC. The Honorable Supreme Court has considered not the constitutional judgment, earlier judgment.
No, I just don't get it. First, let us see what is SK Verma. Then you say it has been overruled. Where it has been overruled?
Yes.
Place those things.
Yes.
You place SK Verma also.
Yes. SK Verma will have page number 10.
Yes. This is directly dealing with development
officer. Yes.
Okay. Where is
Right.
the finding?
Right. Page number 17. Perusal of the above extracted terms and conditions of appointment shows that a development officer is to be a whole-time employee of the Life Insurance Corporation of India, that his operations are to be restricted to a defined area, that he is liable to be transferred. He has no authority whatsoever to bind the corporation in any way. His principal duty appears to be to organize and develop the business of the corporation in the area allotted to him, and for that purpose to recruit active and reliable agents, to train them, canvass new business, and to render post-sale services to policyholders. He is expected to assist and inspire the agents. Even so, he has not the authority to appoint agents or to take disciplinary action against them. He does not even supervise the work of the agents, though he is required to train them and assist them. He is to be the friend, philosopher, and guide of the agents, working within his jurisdiction and no more. He is expected to stimulate and excite the agents to work while exercising no administrative control over them. The agents are not his subordinates. In fact, it is admitted that he has no subordinate staff working under him. It is clear that development officer cannot, by any stretch of imagination, be said to be engaged in any administrative or managerial work. He is a workman within the meaning of Section 2S of the Industrial Disputes Act. The next we got the judgment. Page number 41, paragraph 7.
Page number?
Page 41, running page 41. The next judgment, Lord HR Aditya versus Sandor India. Paragraph 7. Keeping in view the question posed at the beginning, we are obligated to make a survey of the authorities that have been pronounced by this court, specifically pertaining to the development officers working in LIC. A three-judge bench of this court in S.K. Verma versus Mahesh Chandra adverted to the definition of workman as originally defined under Section 2S of the Act and the substantial amendment that was brought in 1926 in respect of the definition of workman and referred to the decision in Workman versus Indian Standards Institution and dwelt upon the hierarchy of officers working in LIC, the duty performed by such officers, and eventually held thus. The perusal of the above expected terms and conditions requirements shows that full-time employees. So, this paragraph जो अभी हम लोग refer किए, the next paragraph it is submitted that by Mr. Sorensen, the letter senior counsel that the said decision was अच्छा, तो लगता है कि HR आते थे constitution bench उन्होंने वाला नहीं आया है, ये दूसरा वाला है। ठीक है, तो पैराग्राफ 8 को पढ़ लेते हैं। इन HR अदर सेंडो जी लिया इमीडिएट दूसरा हम रेफर कर लिया। सॉरी ये हम नेक्स्ट वाला जजमेंट रेफर कर दिया। लेकिन इसका 14 to 16 मिनट पैराग्राफ 14 to 16 ऑफ दिस जजमेंट देन हम बैक आ जाएंगे। पैराग्राफ 14 to 16 ऑफ दिस जजमेंट। मिस्टर सिंह पेज नंबर 44 पर Mr. Singh delivered senior counsel appealing to the appellant build the field of this argument on the basis of the enforcement authority with the hope that an enormous structure would come into existence, but as we find on a study and emphasis reading of the judgment, we notice that there is no reference to the constitutional bench decision in HR Aditya. The two-judge bench, though has referred to S.K. Verma and Mukesh K. Tripathi, but has not taken note of what the three-judge bench has said in Mukesh K. Tripathi with regard to precedent and ये पर इंक्वायरी होल्ड किया गया था. In our considered opinion, the decision in R. Suresh cannot be regarded as a precedent for the proposition that the development officer in LIC is development. In fact, the judgment does not say so, but Mr. So-and-so led the senior counsel to submit that, inferring that such a decision cases are being decided by the High Court and other authorities. Though such an apprehension should not be there. Yet to clarify the position, we will quote a few lines from Ambika so-and-so versus Gujarat. It has been said long time ago that case is only an authority for what it actually decides and not what logically follows from it. In view of the aforesaid, any kind of interference is not permissible, but evident one, it has dealt with the cases of development officer of LIC. As we find the said judgment R. Suresh has been rendered in place of the principle laid down by the constitutional bench in HR Aditya, and also the principle stated by the three-judge bench in Mukesh K. Tripathi that the decision in S.K. Verma is not a precedent, and hence we are compelled to hold that pronouncements in R. Suresh is per equilibrium. We say so on the basis of the decision in HR.
Yes, after this, what remains?
Not
LIC development officer is not a workman. What remains?
Your leadership well aware of the fact of the judgments and the status that a development officer is not a workman. That has been decided.
So therefore, the reference was itself. But once it is held to be not a workman, the award is to be set aside and you will be given liberty to avail your remedy as permissible.
Your leadership, there is one provision that I would like to refer to. This is Order 47, Rule 1.
There is CPC.
CPC.
What CPC is applicable?
Your leadership, there is also a judgment from our High Court that this provision will be applicable.
Order
Application for
47.
review of a judgment.
Review.
Review.
What?
The writ jurisdiction is review.
You see, it is a matter of perversity. The court did not have the jurisdiction to decide it. He is not a workman. That point was specifically raised. The learned court relies upon a judgment which is an overruled judgment.
Correct. Correct.
Yes.
May leadership point out provision. The explanation, the fact that the decision on a question of law on which the judgment of the court is based has been reversed or modified by the subsequent decision of a superior court in any other case shall not be a ground for the review of such judgment. Now on this, there is a judgment from our High Court. Paragraph number 7. Explanation to Rule 1 to Order 47 of the Code of Civil Procedure provides that a decision on a question of law on which the judgment of the court is based, if reversed or modified by the subsequent decision of the superior court in any other case, that shall not form a ground for review of such judgment. The judgment in Venkatesh so-and-so was rendered on 12th March 18, but before that, a tax appeal number so-and-so was dismissed by order dated so-and-so. However, the decision in MS KL Rathi Steels Limited is a split verdict of the Honorable Supreme Court, and a final decision thereon is awaited. In the opinion of this court, if a review petition is entertained ignoring the statutory provisions under Order 47 of the Code of Civil Procedure, which are applied in the writ proceedings, that would bring uncertainty and chaos in the system.
So we are relying upon this provision.
This provision.
The improved award is dated.
2012 का हुआ।
2012.
डेट बताइए भाई।
हाँ, बताइए।
ऑर्डर में डेट कितना बता?
$28 5 2012।
28/5/2012. When was this S.K. Verma's case decided?
$83।
When was it overruled?
It was 1994. HR Aditya Milot, page number 18.
Just.
11th August 1994.
11/8/1994. It was over. 1980.
Yes.
This provision.
Thereafter, in 2008, R. Suresh, that had the field, that allowed development officers to approach the labor court.
2008.
2008.
2008, R. Suresh
R.
was the
Suresh.
judgment. Okay. Alright. Then thereafter the fresh judgments came when? The subsequent judgment which he has annexed?
Mukesh K. Tripathi Milot,
Yes.
2004.
This is 2004.
अभी अलग से किए हैं and
अब भी अलग से?
हाँ, एक दिए हैं सीरियल नंबर 4 पे
नहीं
जो
ये
है
वाला जो HR
HR आदित्य तो 1994
1994 में ही है ना?
Yes,
उसके बाद R. सुरेश के बाद this happened in 2004.
yes.
R. Suresh
मुकेश के
was
त्रिपाठी
later.
मुकेश के त्रिपाठी
ये R. सुरेश was later.
Yes, 2008.
2008 तो R. सुरेश भी कब overruled हुआ?
R. Suresh was held to be in per inquiry.
When?
ये यही जजमेंट जो अभी रेफर किया सीरियल नंबर मिलॉर्ड 4 पेज नंबर 38 पे है
2015.
2015.
was held to be per inquiry.
2015, volume 7, SCC 263. And this award was passed in 2012.
12.
See, this very well. The award was, but the question of review, the provision of Order 47 Rule 1 comes into play when the judgment has attained finality. Right? Unless the judgment attains finality, there is no role. Suppose there is a judgment passed in favor of one or the other party, and on the basis of some judgment of the Supreme Court, and subsequently after 10 years that judgment is overruled, then he will not have have a right to file an application for review. Right? He can't do it. Okay? Therefore, in such circumstances, review is not maintainable as per CPC. But suppose it is an ongoing litigation. There is a judgment, then subsequently during the pendency before this High Court, Supreme Court and many other places, and it is ultimately held to be a bad law, then certainly it will be maintainable. Order 47 Rule 1 has nothing to do here. It is not a case where he has filed a case pursuant, this review is not, it is not a case of review. Simple. That's it. You will have your remedy wherever. Anything else you have to say?
No, only that.
Heard the learned counsel appearing on behalf of the parties, district petition has been filed for the following relief. The learned counsel for the petitioner, while challenging the award dated 28/5/2012, has submitted that admittedly the respondent was a development officer under life insurance corporation. He has submitted that many points arise for consideration in this case, but if the point regarding jurisdiction of labor court is decided, then at best the respondent can be left to avail his decided in favor of the petitioner, then at best the respondent can be left to avail his remedy as per law. He has submitted that the specific point which was raised before the court was as to whether the respondent number 2 was a workman within the meaning of Industrial Disputes Act. He has referred to the order dated 3/5/2002, wherein an elaborate discussion was made in connection with maintainability of the reference on the ground that the respondent number 2 was not a workman, and the matter was left to be decided upon consideration of evidence to be led by the parties. Correct? He has referred to, the learned counsel submits that ultimately by the impugned order, impugned award, the workman has been held to be, the respondent has been held to be a workman, and while giving the said finding, the learned labour court has relied upon the decision passed by Honorable Supreme Court reported in bracket 1983 bracket close 4 SCC 214. Within bracket SK Verma versus Mahesh Chandra. The learned counsel, while assailing the impugned order, impugned award has submitted that the said judgment was overruled by the judgment dated 11/8/1994 in the case reported in bracket पेज नंबर बताइए ना please.
ये पेज नंबर है 18 से स्टार्ट हुआ है.
Page 18. In the judgment reported in bracket 1994 bracket close 5 SCC 737 within bracket 8 are Ardian and others versus Sandoz India Limited and others. He has further submitted that there was yet another judgment in connection with development officer of LIC which was the case of R. Suresh. Citation बताइए. R. Suresh.
2008-11 SCC 319.
Within that 2008 11 SCC
319.
319. Wherein it was held that the development officer is a workman, but the said judgment, the aforesaid judgments were subject matter of consideration in the judgment reported in bracket 2015 bracket close 7 SCC 263 Chaturya Tripathi and others versus Life Insurance Corporation, and it has been held in paragraph 17 of the said judgment that the development officer working in LIC are not workmen under section 2 in bracket S of the Life Insurance Corporation Act, and the learned counsel submits that under such circumstances the impugned award holding that the respondent was a workman and therefore the impugned award passed by the learned tribunal, learned labour court, cannot be sustained in the eyes of law. The learned labour court has had no jurisdiction to decide the matter regarding the discharge of the respondent.
But he was not confirmed in this case.
Who was not confirmed in this case. Who was not even confirmed in this case. The learned counsel submits that on this short point, the award be satisfied. The learned counsel appearing on behalf of the respondent while opposing the prayer has submitted that when the judgment was passed by the learned labour court on 28/5/2012, the subsequent judgment reported the field was governed by the judgment passed in the case of R. Suresh Sukha, and therefore the award passed by the learned tribunal does not call for any interference. He has referred to Order 47 Rule 1 of CPC to submit that as per Rule 1 to Order 47 CPC, a decision explanation a decision on a question of law on which the judgment of the court is based, if reversed or modified by subsequent decision of Supreme Court in any other case, that shall not form a ground for review of the same judgment. The learned counsel submits that in unfortunate circumstances, the present writ petition challenging the award is fit to be dismissed, and he has also relied upon a judgment passed by this court in Civil Review number 119 of 2019, dated 18th of March 2024. He submits that by referring to explanation to Rule 1 of Order 47 of CPC, the review was dismissed. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that there were different judgments passed by Honorable Supreme Court with regard to the status of development officer as to whether the development officer under Life Insurance Corporation would be covered within the meaning of Section 2S, within the meaning of Workman as defined under Section 2S of Industrial Disputes Act. The judgment which was passed initially holding that the development officer would be a workman is reported in the case of S.K. Verma Supra way back in 1983, and subsequently another judgment was passed in 2008 in the case of R. Sudesh. In the meantime, a judgment was passed on 11/8/1994 in the case of H.R. Adyanathan and others, Supra. Wherein the judgment passed in the case of S.K. Verma Supra was also considered. And it was held to be per incuriam, by paragraph 13 of the judgment. In view of the different views taken by the Honorable Supreme Court, the matter was ultimately set at rest by the judgment passed in the case reported in the case of Mukesh Kumar Tripathi Supra. Wherein, after considering all the judgments, कहाँ है finding इसमें? Wherein it has been observed that in paragraph 23, ये जो overrule किया है,
HR adapter वाला है page 27, it has been held per incuriam.
ये पर इंक्लूडियन तो हो गया, उसके बाद
ये HR adapter देखा गया ना, उसके बाद जो है
ये वाला 2015 वाला तो हाँ,
paragraph
ये
9.
अलग अलग सेटिशन है, 2004 में in the judgment reported in bracket 2015 bracket clause 7 SCC 263, it has been ultimately held that the development officer working in LIC are not workmen under section 2 bracket S of the Industrial Disputes Act. Paragraph 15, paragraph 15, 16 and 17 are quoted as under. This court is of the considered view that in view of the judgment passed by Honorable Supreme Court reported in bracket 2015 bracket clause 7 SCC 263 and also the judgment passed in the case of H.R. Adjournment reported in bracket 1994 bracket clause 5 SCC 737, the improved award passed under the provisions of Industrial Disputes Act treating the petitioner as workman cannot be sustained in lines of law. So far as the argument of the respondent by referring to Order 47 rule explanation to Rule 1 of Order 47 is concerned, this court is of the considered view that the same does not apply to the facts of this case in view of the fact that the present litigation is challenge to the award, and it is not the case where a review petition has been filed by this court pursuant to any subsequent judgment passed by the Honorable Supreme Court. This court finds that the present petition was filed way back in the year 2012, and in the meantime, the law has been set at rest by the Honorable Supreme Court, and accordingly, the judgment passed by the Honorable Supreme Court reported in bracket 2015 bracket 7 SCC 263 is binding on this court. Consequently, the this court also finds that the judgment which has been relied upon by the respondent in civil review number 119 of 2019 was a judgment in which a review petition was filed seeking review of the judgment passed by this court by referring to a subsequent judgment, and this court rejected the review application by referring to explanation to Rule 1 to Order 47 of CPC. The said judgment also does not apply to the facts and circumstances of this case. In view of the aforesaid findings, the impugned award is set aside on the short point that the learned tribunal had no jurisdiction to decide the dispute involved in the present case, treating the respondent as a workman. However, it will be open to the respondent to avail his remedy as may be permissible under law. If such a remedy is availed, the other findings, the same will be decided on the basis of materials to be considered by the appropriate authority without being influenced by any observation / finding in the review.
ये क्या होगा सेक्शन 2S आ गया 2S ऑफ इंडस्ट्रियल डिस्प्यूट्स एक्ट
हाँ, हम करेक्शन हम बहुत ज़्यादा करते हैं।
नहीं वो सब देखते में लग गया वो ऐसे ही लिखा होता है
जहाँ भी 2S है उसको इंडस्ट्रियल डिस्प्यूट्स एक्ट।
मतलब other points are not required to be considered.
I have not considered it.
एक line indicate
In view of the aforesaid findings, the other points which are involved in the present case need not. This court is not inclined to enter into other points which are involved in the present case.
Item 8 WPC 583 of 2013.
Staying for 4 weeks time, Malas, to file the inquiry report, Malas says, Malas, we have received a communication from the Deputy Commissioner, Malas.
क्या चीज़ का इंक्वायरी चल रही
Malas, since Malas, जमाबंदी of the petitioner has been illegally, Malas, that has been.
Fraudulently lordship that was created without any basis. That has reflected lordship in last order sheets. They have also not.
Where is the petitioner?
Last
Petitioner ही नहीं है तो. Nobody appears on behalf of the petitioner. Counsel for the respondent state. Praise for time. How much time do you need?
4 weeks.
Election के बाद ही रखा जाएगा otherwise deputy commissioner है.
Praise for time to file supplementary counter affidavit in terms of the earlier orders passed by this court. Let this matter be posted on 26th November.
26th.
Maybe
Come.
kept on Malas.
थोड़ा सा और delay कर दिया.
3rd of December, since Malas on 23rd Malas election is going
On
to be
3rd of
held.
December 2024, the supplementary affidavit must be filed by 29th.
Item 9 WPL 328 of 2015.
बताइए
I
आपको
prefer
क्या
2
चाहिए?
weeks time, my lord, so that I take instruction from the client whether he is alive or not.
नहीं, हम लोग assume नहीं करेंगे कि कोई मर गया.
नहीं तो सब्स्टिट्यूशन और इंस्ट्रक्शन भी हम
क्या
लेंगे.
substitution और instruction?
इसीलिए-
आप ऐसा कैसे बोल रहे हैं? यहाँ पे लिखा हुआ it has been submitted by learned proxy counsel that father of
2020 का है वो सुनील जो लिए थे वो एडवोकेट उनके फादर.
अच्छा उनके
2020 का है वो. उसके बाद ही आया. क्योंकि हम लेटर भेजे थे वो रिटर्न होकर नहीं आया वो. इसीलिए हम मोदी के पास क्लियर कर रहे हैं. और कल हमको इन्फॉर्म भी कर दिए थे विद कंसेंट हम बोले.
आप कौन? एडजस्ट करके पेमेंट करने का ऑर्डर इसमें है क्या है?
यहाँ हो जो तो क्योंकि खाली हुआ नहीं हुआ उनसे इंस्ट्रक्शन ये भी हमको लेना हो जो.
उसमें तो वो ऑन द स्पॉट जो होगा कर देंगे इसमें.
नहीं हुजूर तो लेटर चूंकि जवाब नहीं आया इसीलिए हुजूर के पास हम प्रेयर किए थे. इसको आफ्टर 2 वीक्स हुजूर रख दिया जाए हम कर देंगे.
मरने जीने का बात नहीं तुम्हारे. ठीक है ना? टाइम हम आपको दे देंगे.
होना जी.
100 साल तक तो हम एज्यूम ही नहीं करते कोई मरा हो. 100 साल का हो जाता है आदमी तब हम कब रिटायर में
98 में
वापस
98 में. Yes. 98.
The learned counsel for the parties are present. Counsel for the petitioner seeks adjournment. He submits that the matter be posted after 2 weeks, and on the next date he shall not seek any adjournment. Post this case on 20th of November 2024 under the heading for final disposal to be taken up at night.
होना जी.
Item 10 WPC 226 of 2018.
Yes, petitioner.
मेरा एक आईए पेंडिंग है और अमेंडमेंट ऑफ डेट आई वांट टू एड द प्रेयर टू प्रिपेयर अवार्ड इन माय फेवर.
One more IA is pending the ladyship by seeking 16 weeks time
For what?
for
16 weeks.
the
Why
ladyship.
not 1 year? Only 16 weeks.
The ladyship, there is an old
मेरा
record.
जमीन
The question is, the
2002
question
की में दिए हैं.
was
आज
regarding
तक
whether
अवार्ड नहीं बनाए.
the acquisition under the Act of 1894, Land Acquisition Act has lapsed, and the compensation has to be paid according to as per the Fair Compensation Act of 2013. So the record has to be seen, and
पोजीशन किसके पास है?
पोजीशन रेलवे के लिए
railway
जमीन ले लीजिए, उसके बाद बस घुमाते
अभी तक
रहिए.
हमको नहीं
what happens is that when the land is acquired for railway, not whole of the land is utilized. Some land is kept vacant, and the tracks are being laid over on
Yes,
some.
that's right.
So the contention of the petitioner here is that the land which was acquired by the railway has been put to an unutilized use. It has not been utilized. So if it has been unutilized, and if the compensation has to be paid, whether the compensation has to be paid as per the old Act of 1894 or the new Act of 2013, and for that
He continues to be in possession.
acquisition was there.
Acquisition was already done.
Acquisition was there.
Compensation was paid.
No, with that.
Amount was deposited in treasury.
No, that.
It will lapse.
It has lapsed under section
that
24 of the.
For that purposes only, we have filed an IA because it is an old record of 2002. So.
Railways party है.
रेलवे पार्टी
रेलवे को ही ना पार्टी बनाना चाहिए. रेलवेज के लिए एक्वायर हुई थी जमीन. सारा कहानी वही बताएंगे. ये स्टेट तो सिर्फ टाइम लेना जानता है. रेलवेज के लिए लैंड एक्वायर हुआ.
इसका लेकिन मेरा आईए को डिस्पोजल कर दिया जाए.
आईए का डिस्पोजल ऐसे नहीं होगा. रेलवेज को क्यों नहीं पार्टी बनाया है? आपको नहीं लग रहा रेलवेज इसमें पार्टी होना चाहिए? तो सारा चीज क्रिस्टलाइज हो जाएगा. एवरीथिंग विल बी कम टू द फ्रंट. Isn't it?
Yes,
आप बना दीजिए पार्टी. ठीक है. रेलवेज किस कौन है रेलवे के लिए?
यहाँ तो डिविजनल
नहीं, रेलवे की यूनियन ऑफ इंडिया की पार्टी में है.
नहीं,
रेलवे का अलग पैनल होगा.
हाँ, डेफिनेटली रेलवे अलग एक पार्टी होगा, but that is represented by the lawyer Union of India.
यूनियन ऑफ इंडिया के काउंसिल को बुलाइए. रेलवे की तरफ से काम. सर उनको पार्टी बना देते हैं. आपका स्टोरी यहीं खत्म कर. ठीक है. कि लैप्स किया नहीं किया क्या हुआ, आपको भी टाइम दे देते हैं अपना रिप्लाई जो भी आपको फाइल करना है. आइए. Learned counsel for the parties are present. IA number 10453 of 2024 has been filed seeking extension of 16 weeks time to comply the order dated 11/9/2024. The learned counsel for the respondent has submitted that the records are old and therefore it's one of the moot question which may come up for consideration is whether the old Land Acquisition Act, whether the proceeding under Land Acquisition Act 1894 has lapsed or not, right? Considering the submissions, the matter is adjourned and is directed to be posted on 4th of December. नहीं होगा. 4 महीना और आपको लंबा चाहिए. February. आप अभी आपका जो टाइम कैलकुलेशन है वो अगले साल पहुंचे. 16 वीक्स कितना हुआ? 4 months. कब होगा 4
Maybe
months?
the opening week of the New Year.
अभी आप सितंबर, अक्टूबर, नवंबर, दिसंबर, जनवरी, फर्स्ट वीक ऑफ
जनवरी में.
फर्स्ट वीक फरवरी का थर्सडे. आप चिंता मत करिए. आपको तो इंटरेस्ट के साथ मिलेगा. आपको चिंता.
फर्स्ट वीक ऑफ जनवरी कर दिया जाए. 16 weeks तो ब्रेक ही है. Maybe if we could get hold of the document.
फर्स्ट वीक ऑफ जनवरी का वेडनेसडे. ठीक है. At this, it has been submitted by the counsel for the parties that the land was acquired for railways. Possession किसके पास है? पोजेशन होने से भी लैप्स नहीं करता, डिस्पोजेस होने से भी लैप्स नहीं करता है, नहीं करता ना। पुराने एक्ट में अगर डिस्पोजिशन हो चुका है तो लैप्स नहीं करेगा, पैसा जमा हो चुका है तो भी लैप्स नहीं।
पैसा नहीं जमा हुआ है, अवार्ड ही नहीं बना है।
The counsel for the petitioner is directed to add रेलवेज का किसको हम लोग पार्टी बनाते हैं? कहाँ है रेलवेज का नाम भी कहाँ
सेक्शन 3 में पेज 35 में आपको साथ ही सूचित किया जाता है कि नई रेलवे लाइन निर्माण हेतु भूमि का अधिग्रहण किया गया है।
इस रीजन का हाईएस्ट अथॉरिटी कौन है इस रीजन का?
डीजीएम।
साउथ ईस्टर्न रेलवे का डिविजनल मैनेजर इज द हेड,
divisional manager of South Eastern Railways as responding number 6 in the present case. 5 कौन है? Respondent number 5?
5 मेरा ब्रदर है, मेरा
respondent number 6 in the present case and serve 2 copies of the entire date records to the retained counsel of railways and file a receipt thereof along with the retained counsel of railways along with a copy of this document. The counsel for the railways is directed to seek instruction and file an affidavit in connection with the land involved in this case with particular reference to the possession of the concerned party and if the possession has been taken by railways, then the date of taking of such possession. हुआ होगा ना इसका? अच्छा, काउंटर एफिडेविट खाली फाइल करते हैं, इसके बियॉन्ड कुछ नहीं, ओनली काउंटर एफिडेविट, राइट, प्रायर टू द नेक्स्ट डेट. The deed will be done by the petitioner in writing during the within a period of 1 week from today. कितना दिन में कर देंगे एड पार्टी? अभी कर देंगे? During the course of the day.
Validation January 1st would be the first Wednesday.
January 1st to 2nd. उस second Wednesday को डाल दीजिए. In the supplementary process. देखते हैं क्या?
Item 11 WPL 2738 of 2018 along with
जनरल मैनेजर होते हैं. आप ना पूछ के बता दीजिए, आप जब इंसर्ट कर देंगे ना, जिस अथॉरिटी को इंसर्ट करेंगे वही हमारे ऑर्डर में रहेगा, ठीक है? थोड़ा बस रिस्पॉन्सिबिलिटी से कर दीजिए इसका. यस.
In one of the matters, Workman has died also. We have to.
In one of the matters means?
2 matters are died.
There are 2 different awards. There are 2 different awards. So you argue whatever in case where the workman has died, we don't need to worry. You file a, you are for the petitioner.
Yes, ma'am.
Employees.
For the workman.
Dilip Nandi, who has expired?
Swapan Kumar H.
Who has expired?
Swapan Kumar H. 2735.
Sapan Kumar H. Dilip Nandi, you can argue Dilip Nandi?
I'm not quite counter. Only one thing is necessary in this case. The domestic inquiry, the only question they have raised, that domestic inquiry found to be proper, and that has not challenged, that has attained its finality. The only question he has raised in the petition, that while he was in the custody, second show cause was served to him. He has stated that some time may be given, and as per the standing order, if a person is in custody, it can proceed. Everything was done, inquiry, everything. Only reply of second show cause, he has stated that he was not given the opportunity. This is the.
He has challenged the order of domestic inquiry.
No.
Is there any challenge?
No. That has been found proper. That has come to its finality. The petition, Your Lordship, the prayer may kindly be seen. He has only challenged that I was not given to give reply of the second show cause as I was in custody. So I have
See, the domestic inquiry is held to be fair and proper. You can challenge it once the award is passed, but there has to be specific challenge to that award. Where is that? There is no challenge. Then?
But so I will be taking the ground that the charge sheet and order of inquiry and later of second call and.
Do you appear for railways, Mr. Anil Kumar? Do you appear for railways also?
Yes.
कौन अथॉरिटी बनेंगे? यूनियन ऑफ इंडिया थ्रू कर रहे हैं?
Yes.
इसमें एक प्रॉपर्टी है रेलवे का एक्विजिशन से रिलेटेड।
किस एरिया?
यूनियन ऑफ इंडिया थ्रू इंडियन रेलवेज कर रहे हैं? क्या कर रहे हैं?
ऑफिसर लोगों के रेलवे डिवीजन के जो रांची डिवीजन में आएगा वो जॉर्डन उनको बनाना पड़ेगा।
यूनियन ऑफ इंडिया को नहीं बनाए, जनरल मैनेजर रहते हैं यहाँ।
डीआरएम
डिविजनल जनरल मैनेजर, डिविजनल जनरल मैनेजर। इंडियन रेलवेज, साउथ ईस्टर्न रेलवेज, साउथ ईस्टर्न रेलवेज रांची, ठीक है? डिविजनल रेलवे मैनेजर, साउथ ईस्टर्न रेलवेज रांची। आपको कॉपी सर्व करा है, इनको कॉपी सर्व। इसमें एक्वायर हुआ है लैंड 19 पुराने एक्ट। अब ये नहीं पता पोजेशन किसका है, डिस्पोजेस हुआ है नहीं हुआ, आई डू नॉट नो व्हाट इज दिस। इन लोगों का कहना है हो सकता है लैप्स हो गया होगा। लैप्स तो तभी होगा ना जब पोजेशन नहीं होगा, कॉम्पनसेशन नहीं होगा। अब इनका कहना है कि हमको कॉम्पनसेशन नहीं मिला है, तो कॉम्पनसेशन आपने कहीं जमा कराया होगा, तो कहाँ पर है? तो इनका एक गरीब आदमी लोग का ये सब चीज़ पेंडिंग नहीं रहना चाहिए, वेरीफाई करके बता देंगे। और इनका कहना है कि अवार्ड बना लिया जाए तो उनको पेमेंट हो जाएगा, बस इतना ही तो है। या हो सकता है अवार्ड बना हुआ रखा, उनको पता ही नहीं।
बहुत पुराना मैटर होगा उस समय। वहाँ पर 1950s के समय में जितना लैंड एक्विजिशन हुआ था उसका प्रॉब्लम अभी भी चल रहा है।
हाँ।
पूरा लोहारदा का सिटी जो है वो रेलवे का लैंड, उसके लिए एडमिनिस्ट्रेशन, डिस्ट्रिक्ट एडमिनिस्ट्रेशन से कोरेस्पोंडेंस चल रहा है। वो फाइल हम इतना मोटा फाइल हम देखे हैं इसलिए।
हाँ, तो उसी में से होगा।
उसी में से होगा ये जमीन।
अगर मान लीजिए ये अपना कॉम्पनसेशन लेना चाहते हैं तो इनको दे दीजिए, फिर क्या है, अवार्ड तो बना हुआ होगा। हाँ, यस।
रेलवे मैनेजर साउथ ईस्टर्न रेलवे।
So I am taking the ground that the departmental proceeding was not fair and proper.
So where have you challenged the order? There must have been a separate order. Where is it?
And they have not annexed the domestic inquiry.
But this matter will come up after 6 weeks now.
It will come after quite some time. January में, 8th of January.
I have added
You have added?
Union of India.
That's it. We will do the need. उनको कॉपी सर्व करके रसीद फाइल कर दीजिए।
नहीं, domestic inquiry fair and proper जो order हुआ है वो नहीं लगाया। That has not brought on record. I have received.
And it is not even under challenge.
Yes, and that is not on the record. I have received the record. It is with me. I can bring it on record that the order of domestic inquiry was fair and proper. That is not on the record. How the court has passed an order of fairness. And the grounds taken your relationship that
इसका record आया है
नहीं अब इसमें
ऑर्डर आप लगा दीजिए नहीं आया वैसे कौन से ऑर्डर से डिसाइड हुआ
26/9/13 is the domestic inquiry order ladyship. It is in the it is stated in para 8 of the order. Para 8, page 53. It is the WPF 2738.
It is 29/6/13
29/6/13. What got 8 para? Onwards is the discussion.
Yes, क्या हुआ क्या है इसका
This is why I will say that the authority which issued charge sheet and set up the fundamental proceeding.
You are not getting it. Who is your senior? You will argue it yourself.
We say this.
तो जाकर उनसे पूछिए वो देखिए वो मैडम बैठी हैं मैडम स्वाति साली you just help. In a case where the domestic inquiry is held fair and proper, there is no challenge to that order, and he has challenged the final award, and he wants that since there was no second show cause, therefore the award is banned. Padhi. She is your senior, no?
No, I'm not the senior.
You are senior by length of practice.
I joined it very late in this.
When did you join?
My enrollment is from 2008.
2000. I'm 16.
Good. You have much exposure to. She has good exposure to industrial
In
law.
High Court, I started in 2007.
No. Anybody can learn anytime. I'm still learning. Okay. So you just discuss. You can have a discussion, and then come. Otherwise, I will not be able to unnecessarily to you. Quite unnecessary. 2:15 बजे आएंगे? आइए. ठीक है. कुछ मैटर्स फिक्स्ड होंगे उसके बाद. दूसरा वाला केस में भी सेम स्टोरी.
In second matter, substitution.
विथ है क्या दोनों मैटर?
Yes.
Okay. Arising out of two different awards? Two different awards? Reference case number 15 and ये है reference case number 3. WPL number 2735 of 2018 with WPL number 2738 of 2018. कौन से ऑर्डर से टैग हुआ था ये? there is no order to tag it. Tag तो नहीं हुआ. The learned counsel for the parties have submitted that these two cases arise out of two different reference cases. The counsel for the petitioner submits that the petitioner in WPL number 2735 of 2018 has expired and he seeks adjournment. Considering the submissions, WPL number 2735 of 2018 is detached and directed to be posted on. बताइए कब रखते हैं?
First week of December.
First week of
December.
substitution कल करना है.
It's 21 days is required to obtain death certificate.
Post on 4th of December. Done. ये वाला शाम second one.
Can I feel that some time is given? I will bring it on the record the order of the domestic.
Record is here. Yes. इसलिए आपको कोई देखना है तो आप लोग रिकॉर्ड देख सकते हैं. सेकेंड हाफ में एक बार आइए देखते हैं अगर शॉर्ट पॉइंट पे डिस्पोजल हो सकता है.
In that matter, my senior's name appear on behalf of the respondent.
ओके. आप तो फिर क्या करें बताइए. डेट दे देते हैं. कब करिएगा? कल करेंगे, परसों करेंगे, मंडे को करेंगे. अच्छे से समझ. ठीक है. फायर स्टोन वाला जजमेंट है, इसको पढ़िएगा. The domestic inquiry fair and proper होने से what is the scope of adjudication and that order is not under challenge. Fair and proper. Okay, so far as this case is concerned, post this case for final disposal on Monday to be taken up at 2:15.
In one case, I have given you a bunch of judgment, but here I cannot hear because I have given you so much judgment to be
So
asked.
language, you see, the provision of law and knowledge can always be shared. Judgments are in public domain. He is not aware, his senior is aware, इसीलिए इनको भेज दिया.
Item 13 WPL 2743 of 2019 along with item 14 and 15.
All these cases are actually the common dispute was there. So the dispute was previously when the employees were employed in our organization, also irrespective from the, they used to get the salary on completion of 1 month. Suppose somebody has been appointed on, he joined services on 20th of the month, he will get it on the next 20th of the month. Subsequently, in order to bring uniformity, also a system was made that henceforth this salary will be paid. For this, suppose for the month of March, it will become due only. But for one-time arrangement, we say that whatever month you have days you have worked extra, it will be given in advance. We will give you 1 month salary, and that will be treated, which will be adjusted at the time of your superannuation. So in this particular case, around 13 days difference was there. But after he retired, after he received everything, he filed an application under section 33C2 that I want wages for 13 days. The days are different in all the 3 cases. We took a common ground. We took 3 defenses. One, 33C2 is not maintainable because it needs an adjudication with evidence. Secondly, he does not require any dues, no dues is payable. And third, Your Lordship, in the impugn order while allowing it, also interest has been awarded, which Your Lordship has already.
You just tell us 13 days or 14 days. The days are fixed. The wages are to be computed.
So days are fixed, but whether they are entitled for those wages
Because you yourself say.
No, we say that has to be, we gave it in advance to them.
Okay.
Suppose Lordship,
So
I have
there was
worked
a
for,
dispute.
there
Whether
was a
it was
dispute.
payable
Yes,
or not.
yes. We say that was paid to you in advance at that time. It was required to be
ज़्यादा
adjusted.
नहीं आप कंटेस्ट कर ले 13 दिन के लिए हम
पूरा
क्या ही
workforce
करेंगे.
3 को अगर दे देंगे, that also we took and I also gave an opinion initially. Why are you fighting out? This is the entire workforce will have to pay.
Those who were in service, everybody is now, after this lordship, at least 10 applications are pending there. And every time it is, because once we pay, then that has, we have to for a, give a.
Is there any adjudication?
Lordship, there is
Let us-
adjudication.
let us
There is a, lordship, whenever they say and we deny.
No, let us see you deny.
Yes.
What
Lordship,
is
I
the
kindly see.
evidence? Whatever little evidence.
Yes. Annex, para 3, lordship, witness has been.
Para 8.
Para 3, 4, no,
So
no,
far
I'm just
as-
discussing this, and then after para 8.
Let's see how many witnesses were examined. What was that? What was your case? Para
Yes,
number
my
2.
case is para 2.
Yes. Let us see para.
Upon notice, OP appeared and filed their written statement stating therein that the proceeding under section 33C2 is a proceeding in the nature of execution proceeding in which the court in which this court calculates the amount of benefit which is capable of being computed in terms of money arising out of the award or settlement. The right of money which has been sought to be calculated or benefit which is sought to be computed to be an existing one that is already adjudicated upon. Wage period for the applicant is from 21 of the preceding month to 20 of the next month, whereas as per the prevailing wage was being paid in the first week of every month after taking into account the 6th day of the preceding month, that is 5th of the next month. As per the appellant's wage period from 21 to 20, where was receiving the monthly wage of 6th of the month by taking into account 6th day of the preceding month to 5th of the next month. Thus, applicant has been given 13 days advance wage every month. The concerned workman retired from service on such and such. At the time of payment of his last wage, he was required to settle the 13 days wages, which were as per the prevalent practice, which was given in advance.
Para number 3.
AW1 Ram Saru Mate himself examined himself on behalf of the applicant in his examination in chief. He has stated that he was posted at Bangabad Kulleri as senior overman. He was superannuated on 1/11/2011 on his retirement. Has wrongly deducted 13 days wages from his last month's wages. In cross-examination, he has stated that he has joined the service on 17/10/71. At that time, he was working as a loader and he was getting wages on weekly basis and for alternate week. He was further superannuated in service on 31/10/2011. He is entitled to get wages from up to 31/10/2011. His attendance period for 5th or 6th or to 5th of the month, and bill was paid from 20 to 20, 21 to 20th day of the month. This is not true that amount of entire month of October has been paid on the basis of payslip. He has proved the following facts. Letter
What
of
is Exhibit B?
Exhibit B is the area chart of selected separated employee for NCWA.
So it must be the area chart. It must be mentioned in that. It is your document. Is it your document? Did you lead any evidence?
Yes, we led evidence. It
Where
is our
is-
document.
Where is it mentioned? About your evidence?
My evidence is not discussed. Only exhibit 1 and 2 has been discussed.
What is Exhibit B?
I don't have the copy of the exhibits. Just that we find to show how areas have been completed.
The records have also come in this case. Any counter affidavit filed?
Yes, counter affidavit has been submitted.
You see Annexure C. Annexure C to the counter affidavit of.
Yes.
This is Exhibit B. This is Exhibit B.
Yes.
Yes. Area.
NCWA 9 areas were selected
Yes.
separated in.
This is the area figure.
They have to show that it is there in that figure.
Yes.
This is what we had filed to support our.
We do not know who filed.
No, no, this is on
This
implementation
is
of
Ram Swarup Mehto.
Yes, his
His area is mentioned over here.
so that areas
Is it
have
matching?
been paid. That areas have been paid.
That area has been paid.
Yes, that is it is not for that case. But so NCWA 9 was given a retrospective effect because every 5 years there has to be a wage revision. So it is NCWA areas which was calculated with respect to separated employees. If your lordship sees total on implementation of NCWA 9, total 39,777.81 rupees was additionally found payable. That has been paid.
Where is the respondent?
Ranjan Singh.
It also says that you have not filed any document. Nothing has been
But the
filed.
documents have been mentioned in the judgment only.
You see, no order, para number 11. No order or circular or previous payslip has been brought on record by the OP to prove that the management was paying advance wage of rupees 30.
Lordships, once we say Lordship that once we deny the dispute has been raised, Lordships, then your Lordship, any evidence taken, any adjudication would be without jurisdiction. We said that what is our case and we said that it requires an adjudication.
Yes, what do you say?
Look, the imperial order itself says that they have
Industrial disputes.
13 days salary is due. Therefore, it has been ordered. In view of their system, because obviously
So mere denial is sufficient?
Lordship, we have to show that if I deny it, then if I lead the evidence, there has to be an adjudication. Lordship, if once we said that this is our case, not for the sake of denial only, that this is our case and it requires an adjudication. And therefore, 33C2 is not maintainable. And we have brought on record that, Your Lordship, that whatever was payable, even on revision of pay scale also, we have calculated dues and paid it. 13 days was adjustable.
You see, in your show cause, you had said that on the face of the bill or the salary slip, 13 days salary was not paid, right? And when this was not paid, their case was that this has not been paid without assigning any reason, and it was not in dispute that worked till the end. Your case was that it was given to them by advance. There has to be some document.
Some document
You have
can be
produced nothing.
Some document can be appreciated by a court having jurisdiction to appreciate the evidence. That should be taken into consideration. Once we say and they say and we deny it on a ground, not simply say a denial that no, it is not fair. We say that and it is uniformly applicable to the entire workforce. So suppose somebody has joined on 29th, 21st, he is not sure 8 days wages he will get less. But if somebody has joined on 10th, he will get 20 days wages will be adjusted. He continues getting that much in advance. He joined in 17th, therefore not sure 13 days wages.
In my case, the court below has already interpreted. This question has been answered in paragraph 5. So far, maintainability of the case on 33C2 is concerned. OP has taken the defense that wages for 13 days have not been deducted as alleged by the applicant. Rather, defense of the OP is that alleged due amount has already been paid. Thus, controversy revolves around the issue whether wages have been paid or not. It is not disputed that the applicant is claiming the wages as per provision of the National Coal Wage Agreement. Thus, it is not a case of determination of wages or entitlement of applicant. Rather, it is a matter of interpretation of the wages have been that have.
Their case was that it was already paid.
Yes, in that.
Your case was it was not paid. So far as computation is concerned, there was no dispute. The dispute was whether it has already been paid or it has not been paid. Right?
In execution, they have paid 63,000.
This is same in all the cases.
All the cases.
Similar order.
Similar order and with respect to the jurisdiction to adjudicate your lordship's order, which has considered all the Supreme Court order, and lordship with respect to whether interest can be awarded in a certain
Interest पे बता दीजिए आपको क्या बोलना है. Interest पे क्या बोलना है?
Interest per.
The law is covered by a judgment of this court which has not been challenged.
Interest is the integral part of the
Judge,
principal amount.
उनको बताइए judgment बिना देख के मत बताइए. Heard the learned counsel for the parties. The learned counsel for the petitioner, by assailing the impugned judgment passed under section 33C within bracket 2 of Industrial Disputes Act, has submitted that the opposite party had filed a petition seeking wages for certain days. This means that different number of days are involved in different cases, but the point involved is the same. He has placed the facts from WPA number 2743 of 2020. He submits that the application was filed for payment of 13 days wages which the petitioner had deducted while giving payment of terminal dues. The learned counsel submits that when different workmen had joined on different dates in the midst of the month, at a later stage, a decision was taken to have uniformity, and consequently, additional wages for the remaining period of the month was paid in advance with a clear rider that the payment will be subject to adjustment at the time of payment of terminal dues. He submits that there was a serious dispute in connection with entitlement of the concerned workman, and therefore the petition under section 33C (2) of the Industrial Disputes Act 1947 was itself not maintainable, and the learned Labour Court has erred in law in directing the petitioner to pay an amount of rupees 26,016 being the wages for 13 days. He submits that the impugned order is wholly without jurisdiction and therefore it calls for interference. Without prejudice to the aforesaid submission, the learned counsel has also the learned counsel has relied upon judgment passed by this court in LPA number 379 of 2012, decided on 17/6/2020, paragraph 25 onwards, to submit that the various judgments passed by the Honorable Supreme Court with regard to the scope of section 33C2 has been considered. Without prejudice to the aforesaid submissions, the learned counsel for the petitioner has also submitted that there is a direction for payment of interest at the rate of 9% if the amount is not paid within a period of 30 days. He submits that the learned Labour Court had no jurisdiction to direct payment of interest, as the amount recoverable under on account of computation under section 33C2 is recoverable as a certificate proceeding, which itself has statutory interest. He has relied upon judgment passed by this court in WPL number 6967 of 2017, decided on 19/6/2023. He has referred to paragraph 28 to 30 of the same judgment. The learned counsel, appearing on behalf of the respondent, but representing the respondent Workman, has submitted that the impugned order is a well-reasoned order which does not call for any interference. He has also submitted that it is not in dispute that at the time of payment of terminal benefit, the wages to the extent of 13 days was not paid. He has also submitted that so far as the quantum of wage is concerned, the same is also not in dispute. The petitioner did not file any evidence to show that the wages for 13 days was paid by way of advance. He has referred to paragraph 8 of the impugned order to submit that the maintainability of the case under section 33C2 was decided by the learned Labour Court by a reasoned order as mentioned therein, and therefore, and there is no perversity in connection with the point of maintainability as decided by the learned Labour Court. The learned counsel submits that in view of the aforesaid facts and circumstances, the impugned order does not call for any, impugned judgment does not call for any directives. ठीक है? मैम कल लिखा थोड़ा देख के लिखा. Arguments are concluded. Post this case for further discussion tomorrow. Yeah, Monday. At 2:15, right? ये कितना matters? 4.
3.
Is there any more pending?
होगा तो लक्ष्य immediately mention it so that's
Mention करके आ जाएगा तो एक ही साथ हो जाएगा.